According to satisfaction. Just a little bit of side note, a very important one before you run off trying to do it. You must understand the principles of assignment of contract and how whenever a contract is assigned, the interest to it is obtained by the one who it's assigned to, as though they were the one who initially entered into that contract. So read the clauses that deals with assignment. It's like real estate. When you assign contract, same thing. You can do it with any other piece of paper. If there's an assignment clause there, cross it out, X it out, and then put your hands on it and get copies of it. Because that's one of the things that could bar you from being able to enforce according to satisfaction. And some contracts even have clauses that is anti-according to satisfaction. If you're using this for any type of vehicle, automobile, whatever other property, mortgages on a land or a house, or any type of contract that creates liability on your end and demands performance, actually read it. Don't just go into the closing table doing stuff because you think someone has told you something that you can just do. No, read those contracts. According to satisfaction is based on contract law, due process, both parties being aware, bilateral contract, good faith. If it's based on contract and you don't read the contract itself, then you're just looking for some easy way out. According to satisfaction is an agreement, which is an accord, between two contracting parties to accept alternate performance to discharge a pre-existing duty between them and the subsequent performance of that agreement. An accord of satisfaction differs from modification in that a modification immediately discharges a pre-existing duty, whereas an accord of satisfaction does not discharge a pre-existing duty until the agreed upon, this is the most important part, alternate performance occurs. And within an accord of satisfaction, it gives you those stipulations of what they must agree to and what actions they must take for those things to be considered an agreement. So here's the important part, which is like a trick bag that they will use against you. Just keep it in mind. And it is this. Say you go to a dealer and get an automobile, right? And then you finance the automobile and you're paying a monthly bill. Whenever you finance the automobile, pay attention to who is financing it. If the dealer itself is not financing it, then you've got yourself in a trick bag. Meaning, when you're doing according to satisfaction, you're not going to be doing it to the dealer. You're going to be doing it to whoever that third-party entity is that's financing it. A lot of people screw up and do according to satisfaction to the dealer themselves, and then try to enforce according to satisfaction in public court, bringing the dealer in, or bringing in the third party, when in truth you never turned in any offer of according to satisfaction to the proper party, and your case will be dismissed. Because the moment that that agreement was signed, that you'll be financing the car, which is separate from the purchase agreement. Sometimes they separate it like a launch with mortgage and promissory notes. But it's the same foundation of how it works. That's what goes on. When you purchase that vehicle or automobile, whatever you want to call it, there's another document that you sign that subrogates you to another party. And there's usually an assignment clause within that initial contract that says the moment that you sign this financing instrument, the dealer has nothing to do with it. It's you and whoever is fronting the money that car is worth, that you're going to be dealing with. All the dealer is just doing is they're acting as the advertiser, or the one who just distributes that product to the general public. The back end money of it is different. Whoever, it's another entity that deals with it. So now you're going and doing according to satisfaction to the dealer. They will take your money. They will cash it. But guess what? The moment that that bank starts to finance that car, which is another entity, They have effectively bought that contract that you signed, and now they are the interest holder of that contract. So the one who you're supposed to be doing that according to satisfaction to is not the dealer, but the one financing that car. Because the bank pays the dealer, and the dealer gets their money. Whatever amount that car is supposed to be worth, the dealer gets all that money. And because the dealer have been satisfied on that end, the bank now has to hold somebody liable for the money that they just put out in their other side of their ledger as a receivable. And that effectively subrogates you because you are the possessor of that liability. Besides the fact that you have to fix it and then the value goes down and you have to buy gas in it, not that liability. We're talking about the liability of the fact that somebody had front money of amount that that car is worth, and now you, the possessor of it, is not liable. So if you're going to do an according to satisfaction that is being financed, even though you bought it from the dealer, look deep into those papers that you signed. The dealer is not going to be the one that you're going to be doing according to satisfaction to. Don't play yourself. But wait, you now might want to bring up the concept that, well, that bank was not there when I was at the closing table. They weren't physically, and they can't. But you entered into a contract to get them to finance it, didn't you? You sure did. They were not the party which you agreed to purchase it from, but they were the party that you agreed to finance it. So you didn't purchase that automobile vehicle from the bank. But remember the concept of a sign-in contract? The one that you purchased it from just got the money fronted to them by the bank and then dumped you as issuing liability to the bank's hands. That I signed that contract, that purchase agreement, that you might want to say, well, the bank wasn't the one that I purchased it from. Well, technically, if they're paying technically and literally, and actually, if they're paying the dealership that you think you're purchasing it from, then really when you think about it, they are the ones that you're purchasing it from, the bank. And that is why they're financing it. They financed it. The fact that they financed it, meaning they're the ones who front you the money. On your behalf, they gave it to the dealer. And now you're going to be paying them residual income based on interest monthly. That's how they make their money. The dealers made their money up front from the bank. The bank was part of the whole deal right from the beginning, regardless of how it appeared to you, whether you realize it or not. So now the bank becomes the first lien holder to the title of that thing that you call your property, your car, your vehicle, your automobile. So now on the certificate of title, it has the name of the bank as a first lien holder. It has the name of whatever entity you're using or your name as the owner, but who the first lien holder is the bank. And I guarantee you, even if it doesn't illustrate that on a certificate of title, do your deep research enough and you see who really owns it, and the fact that they do have lien on it. So if you now try to trade that one in, it's going to show that there's a lien holder on it and that there's a liability that's yet to be satisfied. You want to take this to court and say that I did according to satisfaction, that's considered bad faith, because now it appears as though you're willingly giving the wrong party the according to satisfaction, but in truth you're supposed to be paying monthly payment to another party somewhere else. Know what you're doing and be well aware of the dynamics of how contract work beyond what you're trying to do. Be savvy to how contract works based on what is being done outside of what you're doing. That is assignment of contract and the principles of subrogation. Whoever puts the money down is the one in power. The bank is putting the money down. They become the first lien holder of that property. The dealer is just a front, just to advertise that property. It's really that simple. So the one you will be doing your according to satisfaction to is whoever that financing company acting as the bank is, not the dealer. Keep that in mind.